is negotiating access and compensation agreements.
Correct, Phil.
Why have you chosen that topic today?
We've had a lot of access and compensation agreements come across our desk, not just for mining, but for other resources such as wind farms. And we thought it was high time that we kind of address the issue, gave you some, I suppose, pointers when it comes to access, compensation, what your rights are, and some things to consider if you are approached by a mining or resource company.
And a wind farm proponent.
Yeah, exactly. I mean, that's it. There are, I suppose, different companies out there that are proposing access and compensation, and like Phil said, it doesn't have to be for mining, it can be for other activities, but that is a common one that we're seeing, obviously.
Yeah. Okay, so we've been approached by someone who wants access to our land.
Mm-hmm.
What should we really be doing?
Well, asking what's your land? Are you on private land or are you on Crown land? That's the first question.
Yep.
Because that dictates, I suppose, the access rights and what you're entitled to say to someone that's approaching you.
Yep. Okay, well, let's deal with, say, freehold land.
Yes.
That's probably the easiest and most common through the southwest.
Absolutely.
In the context of, let's say, a wind farm proponent,
Mm-hmm.
are there any rules or laws which give them a right to access without consent?
You need consent. They need to obtain the owner and the occupier of the land's consent. So if you're the registered proprietor on title of that land, if you're a farm, there might be obviously multiple lots, then they need to seek your consent before they enter the land. There are obviously avenues to seek a permit. But when it comes to wind farms, that's for mining, I'm saying. But when it comes to wind farms, no, they need your access in order
Your consent.
Your consent in order to access.
Yeah. And mining is a little different.
It is, yes.
Yeah.
So under the Mining Act, a mining proponent can seek a permit to enter the land, sort of mark out the land for potentially mining or exploration activities. So the permit's the first step, which they can use to gain access. And then obviously if you don't consent to them accessing your land or they don't get a permit, then there's obviously the avenue of seeking a tenement application to enter the land.
Yeah. So under the Mining Act, in relation to freehold land, the typical approach is to obtain an exploration permit.
Yes.
The department issues a permit for that land which is below 30 metres below the surface.
Yeah.
Bit of a conundrum, the Act itself, but in the context of the top 30 metres, does the farmer, because it's agricultural land,
Yes.
do they have what's called a right of veto?
Yes, they do.
Right.
So, a mining proponent needs consent in order to access that land, because any land that's for cultivation, agricultural purposes, essentially the owner has a right to deny access because it's like an exempt activity, I suppose you'd say.
Yeah.
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 That's probably the extent of what I'd say.
Okay. Does that right exist for someone who's on a Crown lease, pastoral lease?
It's different. So,
Yep.
so with Crown land, you might, you're typical, we see pastoralists, they have a pastoral lease over the land. They're not the owners of that land, it belongs to the Crown. They have a leasehold over the land, which gives them a right to be there. And as we know, typically these leaseholds are for, 50 plus years. So they have a right, and that's registered on the title, but it's Crown land at the end of the day. So although they can deny access, it's not the same as a private landholder's right.
Yeah, so the right of veto doesn't apply in those circumstances.
Yes,
Yeah.
correct.
And we need to bear in mind too, though, I guess, that under the Mining Act particularly, there's a regime for compensation to be paid.
Yes, absolutely.
Right. What is that regime?
So any owner-occupier that's, I suppose, affected by mining activities, that will be, has a right to seek compensation. And that compensation is for damage or loss that might occur on the land as a result of these activities. So we're talking, there's it's a whole regime of compensation, but essentially we're talking about damage or loss that's in connection with those activities, that's directly caused by them. And it's recommended that you have those discussions early on about compensation if you're approached, because it can be broad, and they can be, you can cover for loss of use of the land. Like if you're running livestock or you've got a crop on that land, that's one of the typical heads of compensation.
And what form does the compensation have to take?
Well, it could take many forms.
Right.
And I suppose that's why when you're approached, it's not just a one-way answer. So there are some proponents that will look at purchasing land and, or leasing land, and they'll compensate you in that regard. There's also other sort of compensation models where a proponent might pay you an upfront cost, they might pay you an annual instalment, or they might pay you in a sort of itemised fashion according to what losses or damages they perceive or could happen on the property.
And some that I've done where the farmer has managed to secure infrastructure.
Yes.
Like in one situation, in exchange for a parcel of land to be used as a road, the client managed to get installed a big machinery shed and I think a couple of very large water tanks.
Yes, absolutely.
I think we've been dealing with one quite recently too, where the pastoralist has been looking to perhaps obtain water as part of the compensation package.
Yeah, absolutely. So, I mean, water is an ongoing issue, particularly a pastoral setting where water is already sparse. And so if you've got multiple people using that water supply, that is definitely something you can look at in your compensation agreement. If a mining company or another resource company is looking to access water, explore for water, extract water, then you can include that and say, well, if you're going to extract it, I want a certain amount, I want it fed into a tank, which they then install and you have access to. So I suppose when it comes to compensation, it's looking at your priorities, and I suppose what's the biggest loss you're going to suffer? Is it going to be income? Is it going to be lack of use of the land, not being able to access infrastructure, or is it going to kind of be add-ons? And I suppose the improvements to the land, which you can also take advantage of. Yeah,
okay. All right, so we're the owner of the land, and we have let's say a wind farm proponent, and we're saying, all right, well, come on, that's okay. We've sorted out issues of compensation. What are some of the other issues that we need to be conscious of in a structured written contract?
So it's who's coming onto the land is the first one I'd say. So usually in access agreements, the proponent, in this case the wind farm, they'll have a provision in there as to who kind of their representatives are that can access the land. And that can include, employees, the company, contractors, subcontractors.
Contractors and subcontractors, So the proponents don't usually get their hands dirty.
Exactly.
And so they'll farm out that development work to a subcontractor. What sort of risks does that pose for the farmer?
Well, what firstly comes to mind is the new Work Health Safety Act. So there's, as many of you know, there's been changes to the work health safety laws in WA, and one of the new changes in terms of insurance. So previously, but people would have insurance to pay, penalties and compensations if they were, prosecuted or charged under the Act. Now you can no longer take out insurance policies that indemnify you if you are found to be in breach of the Act.
So they prohibit the indemnification of penalty. And those penalties are pretty steep.
Oh yeah, there's been a massive increase, and I think that's something we have to be aware of, because when you're talking about compensation, you have to consider the insurance. Are they going to cover insurance? What's your insurance policy? Does it extend to third parties? To what extent? But again, like, insurance is just one of them. There's other things to consider in compensation. I mean, in terms of like fire risk, pests, vermin, weed control. I mean, they're the things that get overlooked, but they're important.
And so what if things go wrong?
well, that's when you need a dispute sort of resolution provision in this agreement.
Or a right to terminate?
Oh, absolutely, a right to terminate. I mean, it's a case of, okay, what grounds can you terminate? Is it I suppose, a minor breach of the agreement, or is it a substantial breach?
Yep.
In most cases, it would be substantial. But it's considering, okay, and who has that right of termination? Does notice have to be served? What time frame? It's setting out the procedure so that the agreement can come to an end in certain circumstances.
Yeah. Okay. Are there any other sort of special issues, particularly for pastoral lease land, that come to mind?
Well, as we've discussed in previous lives, carbon credits and so is carbon farming is very popular in the pastoral industry. And one of the issues that we've seen is when there is a carbon project on a property and a mining application or a mining company or another resource company is seeking to use that land. How do you compensate the pastoralists for the lack of potential carbon credits that could be generated from that project if the tenement covers an area where you've got that project? And I mean, carbon projects, as we've discussed, are long term, so it's, I suppose, considering that in your compensation agreement, is the pastoralist going to be adequately compensated for loss of carbon credits? But also, how do you predict the carbon credits in the future? And that's a whole other issue, but that's probably an important thing to raise.
Yeah. And similarly, there's a number of tenures, if you like, in the context of freehold. You have freehold land, you have leasehold interest, and we tend to concentrate on crown leases, so pastoral leases more so. But recently we've come across one of those perpetual leases, which were handed out, I think, after the Second World War a lot. And then under those perpetual leases, or conditional purchase leases, as some of them were as well, there are obligations to clear the land, right, which now fall foul of the Environmental Protection Act.
Yes.
But there's also a right to convert that land to freehold. But the other thing about those is that the holder of the perpetual lease can't actually grant a tenure or tenement or access for a wind farm unless the minister has given consent.
Yeah.
Right? And so there are some little foibles about these things you just need to be a bit careful about.
Yeah, absolutely.
And you've identified the carbon as an issue too. And carbon projects, I think, because of the way the systems are all working, I think there's more of an emphasis on those types of renewables, if you like, and the access to land.
Well, that's it, and also I suppose what you're doing on that land comes down to it. Obviously, most pastoralists run livestock; that's part of the requirements of their lease. But they might also have a lot of other biodiversity projects on the property. They might be trying to restore native vegetation, have wildlife, and those are all the things that I suppose aren't at the forefront of mining companies when they come into this. And they're the things that if they matter to you, then they're the things that we need to know about and consider in these agreements.
Yeah. We often find, no matter who the proponent is, whether it's a mining company, an oil or gas company, or a wind farm proponent, we invariably find that they do not understand the nature of farming and they don't understand farmers. Just that's it. So, Matilda, wrapping it all up, what's our suggestion?
So don't grant access. If someone rocks up on your farm, I think that's the key one here. If it's private land, know that if you're on Crown land, it is open to mining. As we've said, there are pathways and there are different access, strategies, but it is open to mining. There's different broad and I suppose different notions of compensation, what you can be compensated for. And there's also this issue of insurance that you have to be aware of. But essentially, seek advice when you're presented with an access or compensation agreement. That would be probably our biggest recommendation. Yeah,
I think that's right. Seek advice because there's a lot of sharks out there and they're not all lawyers.
Exactly.
Okay, what's our next topic?
Well, we're going to touch on a subject that's come up recently, raised last year, but I suppose more important now, and that is the change to the Aboriginal Cultural Heritage Act.
Yeah.
So there's been significant changes to the Act, and probably in the last 3 months, there's been even more changes happening behind the scenes. So there's been a co-design process happening to develop the codes, the regulations, and I suppose the parameters of this new Act and how it will be applicable to landowners, and I mean private and Crown land. So we're delving into, I suppose, the specifics about that, and I suppose discussing how it will impact landholders.
Thanks, Matilda. And so we'll be doing that, and we've decided to bump the farm family duty exemption down the track a little bit, but we will get to that later this year because
Absolutely.
it is still a key issue, particularly in relation to succession of the family farm and the family farm business, importantly. Okay, well, thank you for your time today. Thanks, Matilda.
Thanks, Bill.
And we look forward to catching you next time. Cheers.